So assuming an organization meets the operational and organizational tests, what does it do then to qualify for tax exemption under Section 501c3? Typically, organizations that aren't able to self-declare, such as churches, are going to need to file either the Form 1023 or the 1023-EZ with the IRS in order to be recognized as tax exempt under Section 501c3. Now, the Form 1023 is a 12-page application with schedules, and there are 38 pages of instructions. So it's not exactly a simple form. It's not quite as bad as this picture here, but it's not super straightforward. And it's not absolutely necessary that the application be completed by an attorney, but it is an area where an attorney can be particularly helpful in terms of providing guidance to an applicant and guiding them through the application process. So the application is broken down into different sections, and I'll talk about a few of the main sections in the information that the application requests here. The first section is just basic identification information about the organization, including whether the organization has an authorized representative or has paid anyone else, such as an attorney, to advise it with respect to the organization's structure, activities, or finances. There's also a question about the organization's business form, such as whether it's a corporation, an LLC, an unincorporated association, or a trust, and the organization will be required to attach its articles of incorporation and its bylaws to the application. There's also a question about the organization's organizing documents, so it's articles of incorporation, and the application requires the organization to specifically point out where in its articles it includes those two required provisions, the purpose statement and the dedication and dissolution clause. And as I mentioned earlier, failure to have those in the articles of incorporation can be a major reason why an application might be delayed for processing by the IRS. The next section of the Form 1023 requires a narrative of activities. This requires the organization to include an attachment with the application that describes the organization's past, present, and planned activities in pretty significant detail. So for each activity that's engaged in or plans to engage in, the organization needs to include information such as a description of the activity, who conducts the activity, when and where the activity is conducted, how the activity furthers the organization's exempt purposes, how the activity is funded, and what percentage of the organization's total time is spent on the activity. So it's important that before filing the Form 1023 with the IRS, the nonprofit, your client, has spent some time really thinking through the business plan for the organization and what activities the organization is going to engage in. And the next section of the application asks for information about financial arrangements with leaders. It requires the organization to list the names and compensation amounts of all directors, officers, the 5 highest compensated employees of the nonprofit who will receive compensation of $50,000 or more annually, and the 5 highest compensated independent contractors of the nonprofit who will receive compensation of $50,000 or more annually. It also requires disclosures about any family and business relationships amongst these individuals or between these individuals and the nonprofit, and then asks additional questions if there are any such relationships. It requires you to list the qualifications of each of these individuals, as well as the average number of hours worked by these individuals on nonprofit activities, and to describe the duties of each individual. Now, qualifications, it doesn't mean you need to list the entire CV of each of these people. It can be fairly high level, and it's not going to be thoroughly scrutinized. But it is important to kind of indicate why this individual was selected and is qualified to serve as a director or an officer of the organization. And another thing to keep in mind when including this information is that the Form 1023 and everything that is filed with it is actually a publicly available document. It can be accessed by members of the public. It should be important to keep that in mind, that everything that's included in the application, the organization is comfortable with being publicly accessed. Now, this section also requires the organization to provide information about how compensation amounts are determined for various individuals who are compensated by the nonprofit, including whether the organization looks to comparability data as to what similarly situated organizations are paying similar individuals, and how the organization makes any non-fixed payments, such as revenues-based payments or discretionary bonuses to its employees. The idea here is that the IRS basically wants to know that the organization isn't using its assets to provide an inappropriate private benefit to one of its insiders or to an employee, and that the assets of the organization are used properly for the exempt purposes of the organization. Now, the Form 1023 also asks if the organization has adopted a conflict of interest policy. Federal law doesn't actually require nonprofits to adopt a conflict of interest policy, But if the organization hasn't adopted such a policy, then the Form 1023 requires the organization to include a lot of information about what policies it will follow to ensure a conflict of interest doesn't occur. And the instructions to the Form 1023 actually include a model conflict of interest policy at the end that can be used by most organizations, although certain updates may need to be made as a matter of state law. The Form 1023 goes on to ask about some specific activities of the organization, including whether it will engage in any political activities. This is a little bit of a trick question because, as we'll talk about in a little bit, 501c3 organizations are actually prohibited from engaging in most political activity. So this is a question that the IRS asks, but it would be problematic for an organization to check yes. It also asks whether the organization intends to engage in any activities to influence legislation. Now, unlike political activities, 501c3 public charities can actually engage in a certain amount of lobbying activities, and we'll talk a little bit about that more later on as well. It asks what fundraising activities the organization will engage in, including whether it pays anyone to fundraise on its behalf. It asks about whether the organization will own any intellectual property and how that intellectual property will be used and made available to others. And it asks about whether the organization engages in any foreign activities. Now, another point of caution here. Just as in the U.S., we would expect another corporation or an entity coming from abroad to go through certain registration and qualification requirements before engaging in activities in the U.S., foreign countries may also have similar requirements. And we typically advise that any nonprofit that's going to engage in foreign activities consult with an appropriate foreign attorney as to any applicable laws in that country to ensure that it is complying with them. Penalties can be as severe as jailing in some countries if you engage in activities without appropriate authorization. And we've seen crackdown in some places, such as Russia and China recently, on foreign NGOs that are operating without appropriate authority. And then the 1023 also asks whether the organization is going to engage in any grant-making activities, including to domestic or foreign organizations, and what due diligence the organization will conduct before making those grants, and how it will conduct oversight to ensure that the grants are properly used. The application also requires the organization to provide financial data, including a statement of revenues and expenses. This is usually 3 to 4 years of data, depending on how long the organization has been in existence, as well as a balance sheet for the most recently completed tax year or other appropriate period. And it's important that this financial data be consistent with other information the organization provides in the Form 1023. So, for example, if your client claims to have made grants, those should be reflected in the appropriate expense line. Or if the organization reports that it received a loan from a director, that should also be reflected in the financials that are included in the application. And then finally, the Form 1023 asks about the public charity status of the entity and whether it will be appropriately classified as a private foundation or a public charity. I'll talk a little bit more about the differences in a few minutes. Now, just a point about the timing of filing the Form 1023. If a nonprofit files the form within 27 months of its formation, so if it's a corporation from its date of filing its articles of incorporation, then if it's granted tax-exempt status, the exemption will be automatically retroactive to its date of incorporation. Now, if it doesn't file within that 27-month period, unless it's eligible for an extension or it meets certain other exceptions, then the date of exemption will actually be the postmark date that it submitted the Form 1023 application. And this can be important for organizations to note in case they form an entity, they don't intend to actually apply for exemption immediately. Organizations can also generally start fundraising before they've received their IRS determination letter, and assuming they apply within that 27-month period, the exempt status will be retroactive to their formation. However, it's important to caution organizations if they are going to fundraise before they receive their determination letter from the IRS that they should notify donors that they're not yet tax exempt and that there's a possibility they may not be recognized as tax exempt, and that donors should confer with their own counsel about how to treat the deductibility of that contribution. Now, the 1023-EZ is actually an alternative application that can be used. It's slightly shorter, quite a bit shorter than the Form 1023 that I was just discussing. It's actually a 3-page application that can be submitted electronically. And the Form 1023-EZ is relatively new. It was introduced in July of 2014 by the IRS. It can be used by most small organizations to apply for tax exemption. By small, I mean that the organization can't have had revenues of more than $50,000 a year in its last 3 years. It can't be anticipating revenues of more than $50,000 a year in the next 3 years, and it can't have assets of more than $250,000. And in the instructions to the Form 1023-EZ, there's an eligibility worksheet the organization should go through before it submits the application. Now, if it answers yes to any of the questions in the eligibility worksheet, then the organization is not able to use the Form 1023-EZ and has to instead submit the long Form 1023. The 1023-EZ requires some identification information about the organization, some information about the structure of the organization, but it basically requires the organization to check a lot of boxes and certify that it's going to meet the basic requirements of Section 501c3. We've heard that organizations that are applying for tax exemption using the Form 1023-EZ are hearing back from the IRS in as few as a few weeks to a few months. This is a pretty dramatic difference because as recently as last year, we were telling organizations that filed the Form 1023, the long form, to expect to wait at least a year before they heard back from the IRS on their applications. Although we've actually seen the processing time on Form 1023s reduced quite dramatically recently as well. Now, the issuance of the Form 1023-EZ by the IRS seems to signal that the IRS is shifting its focus away from screening applicants at the front end towards enforcement at the back end. It also has helped the IRS to clear out its backlog of applications. So at the time it issued the Form 1023-EZ last year, it actually had 60,000 pending applications for tax exemption. So it's been able to get that backlog down by using the Form 1023-EZ. But because it's a new form that's still relatively untested, there's still some questions about it, including whether organizations that use the 1023-EZ may potentially be more likely to be the subject of IRS audits later on. So it's something we'll just have to kind of wait and see. But the issuance of the Form 1023 has the potential to dramatically change the landscape of nonprofits by allowing smaller organizations to apply for exemption more easily without much vetting by the IRS up front.